devices is great too.
Yes.
Perfect.
I've had your
Look at you. Thank you. Appreciate you sitting up in the front.
On my old eyes, they don't seem screened as well from the back.
All right, I think we're going to get started. Welcome, everybody. I know quite a few of you here, which is exciting, but I don't know everybody. My name is Teresa Hurley. I'm the Executive Director of the Contra Costa County Bar, and we are putting this housing law training on in conjunction with Bay Area Legal Aid so that you can learn more about eviction defense in our county, as well as hopefully we will get some people signing up to volunteer for the clinics that Bay Area Legal Aid puts on to be able to help people. So without further ado, I'm going to ask Tamina Alon to come up. She works coordinating all of the housing law clinics with Bay Area Legal Aid, and I've known her also through her work with Family Justice Center. And we're happy to have you here. So thank you.
Good evening, everyone. Thank you for coming out tonight. I know kind of the after 5 o'clock time is always a little difficult. I've been told I'm supposed to stand in the middle, which is very weird, and I cannot go beyond both the screens. So if I seem like I'm just a caged animal, it's because I am. Well, we're going to do tonight, we're going to talk a little bit about some of the new laws that are coming down for housing that have come down in January, and hopefully get some of you jazzed about housing law and wanting to participate in some of the housing law clinics that we do here in the county. Is there anyone in the room who's a current housing attorney full-time or an expert aside from Commissioner Richards?
That's what we're going to point out.
Okay, yeah. Okay, that's great. We're going to be doing a couple things also that are skimming the surface with pretty basic of housing law too, so I just don't want to bore anybody. Please, if you do not have it yet, grab that packet that has all of the slides in it, because we're going to go very quickly through a bunch of these things, and I want you to have that to take home with you, even if we don't go through all the points on the screen. So very quickly, a little bit about Bay Area Legal Aid, who we are and what we do. We are a nonprofit civil law firm in the Bay Area. We serve 7 different counties, and we are all over the Bay Area. We also have a legal advice line, which is a hotline number, which folks call in from all over the place, really. Then they can get legal advice over the phone and be directed to possible representation with our legal aid attorneys. We provide a full spectrum of legal services, not only clinics. So not only do we do advice and counsel and pro per work, we do limited scope representation, we do full representation, we do some affirmative work, we do a little bit of everything. And so we really are kind of try to get in and figure out what's going on in the Bay Area and what the needs are for our pro per litigants and our low income litigants, and see what we can do to assist them through whatever's going on in that area. We have 5 priority areas. Housing preservation, I think, really should be up at the top. I did not make that slide, or else it would be up at the top. Of important things that we deal with at Bay Area Legal Aid, and quite a few of our resources are dedicated to housing preservation. We do mostly tenant side work in terms of representation, but when we do these clinics, we are helping both sides. So we are assisting not only tenants, but we are assisting landlords at the same time, because it's very important for both sides to know what's going on, particularly when the new laws come down as they did in January. So we're not going to be doing this training from a tenant side or a landlord side perspective. It's really just going to be giving you what the law is and maybe telling you a little bit about some problems that landlords or tenants might face in different areas. So this is what we're going to do this evening. We're going to touch a little bit on fair housing in the beginning, tell you a little bit about what we run into in terms of violations of fair housing law. And then we're going to talk about evictions. We're going to go through the basic flow chart of the unlawful detainer. And then we're going to go through some new laws that just came down, the just cause for eviction and rent control. We just got a new law that came down January 1st that is going to be statewide. And then we have some local rent control ordinances in Richmond, and then there's one in Concord as well for Contra Costa. So just a little bit to know about those two. And then I'm going to tell you a little bit about clinics. Hopefully you're not running away at that point. To see if you're interested in maybe coming by and volunteering with us one Monday. We are there 9 to 12 on Monday in Richmond, and we're hoping to expand that if we can get some more volunteers. And if you're looking for something that you can really work through a lot of different participants and do a lot of work for a lot of folks in a very short amount of time, this is the clinic to go to. It's also a great way to scare law clerks. So a little bit about fair housing. You have the right to be free from housing discrimination. So this is something that we see a lot at the clinics, and we end up writing a lot of letters regarding housing discrimination. Really, only two parts. You discriminate in housing because of a protected status. So the big question is, what are the protected statuses and what does it mean to discriminate? So here are the different activities which someone might be involved in where discrimination might take place. It's not only while you're renting to somebody, it's not only while you're in the process of having that relationship. It could be in advertising, it could be in applicant screening, it can be in buying a home, it could be in occupying. So really anything that touches housing. If you're treating someone differently based on a protected status, then that could be something which is unlawful. So here are protected statuses. Federal law covers these guys right here. The little mnemonic here is corn fridge. So it's color, race, national origin or ancestry, family with small kids or familial status, religion, disability, and gender. Now, these statuses are all protected under the Federal Fair Housing Act. On top of the Federal Fair Housing Act, California has other fair housing laws which are going to protect not only these particular protected classes, but a whole bunch more. So California is going to add marital status, age and seniority, source of income. For those of you who know, that's a brand new one where the way it's defined has been changed. Sexual orientation and harassment, gender identity and expression, ancestry, military or veteran status, medical condition, genetic information, primary language, and immigration status / citizenship. So there's a lot of stuff which, if someone comes in and says, I feel like I'm being treated differently because I am blank being any one of these things, it could be something which either DFEH, the Department of Fair Employment and Housing, or HUD is going to want to look into to figure out whether or not there's a complaint in there that they can go after. So SB 329, the Housing Opportunities Act, just a little bit about what changed in terms of the California Fair Housing Act. So number one is race was further defined to include hair texture. So you cannot, for example, go and say, I am going to rent to anybody except folks with cornrows. That is actually now a violation of fair housing law. Military or veteran status was also added. That was not part of it before. And source of income now includes Section 8. So all of those Craigslist ads that you see that say, no Section 8, in bold letters on the bottom, are now violations of the Fair Housing Act. This includes, by the way, if there are folks who are currently on Section 8 or other vouchers, so PAPWA, your VASH voucher, any of those types of subsidies, and they're currently working with a landlord and they don't have those subsidies, and then they all of a sudden switch over and say they get a voucher. And the landlord says, well, I didn't sign up for this, I don't want to be a part of the voucher system. They actually cannot refuse, and that would be considered discrimination if they were not to go through the process of accepting their new voucher, their new status as someone who's using that particular subsidy. We also have some new rules for assistance animals. Service animal has been redefined as an individually trained dog. So California has the ADA, which also, California ADA also adds in miniature horses. But for the most part, if the service animals, we're looking for a dog who is trained to do something to assist with a disability. Now, if you have a hamster, gerbil, cat, goldfish, who is an emotional support to you, they could be support animals or assistance animals. Assistance animal is kind of the umbrella term for all of these guys. But if you hear support animal, emotional support animal, then that's everybody else. Now, I would say everybody else with the exception of wild animals who are not normally kept domestically. So while I may have a cat that is used as my emotional support animal, that I bring around places, I'm not going to be able to have an emotional support tiger and get away with that. But if someone figures that one out, let me know. Just a little bit more about source of income. Source of income is paid to a housing owner or landowner on behalf of a tenant, including federal, state, or local public assistance, and federal, state, or local housing subsidies, including but not limited to federal housing assistance vouchers. So not only voucher, this is any type of assistance that someone could get, any type of assistance that is coming down from a government entity for the most part. You cannot discriminate on the basis of that or refuse to take somebody in as a tenant because they're choosing to use that as part of their source of income. Now, landlords can inquire. They can say, well, how are you, what's the deal here? How are you planning to pay your rent? What is going on? But if the person shows that they are able to pay the rent or do whatever the landlord requires and meets that same criteria that they would set out for everybody. So for example, the landlord says, well, that's fine, but everybody here has to make, off the bar, be able to pay 2 times their amount, make 2 times their amount of rent, for example. Then that type of thing would still apply. You would look at the Section 8 holders' part that they pay and take that times 2. But it would allow the rule to be applied evenly across all of the different categories in order to apply that way. Minimum income requirements only apply to tenant's portion of the rent. That's just what I said. So if the Section 8 holder is, for example, paying $12 in their rent for that month, and the landlord says, okay, well, everyone in this building needs to make twice their income, then that amount, or twice the rent, as their income, then $24 is the amount that that person would have to make in order to meet that threshold requirement.
The one before that, everyone must comply except the owner living at home and renting out 1 room.
Yes, that's right. We will get to all the exceptions, yes.
Okay.
But that's right. So, but that's a good thing to remember. So when you are living at home, California very much protects, and the feds protect as well, the right of an individual to live with whom they want to live with. So if a landlord is living at home and is renting out 1 room in their house, for example, then the rules of who they're allowed to have with them are going to change dramatically because the law is going to allow for them to freely associate the way that they want to. So yes, that's a very good point.
So on that point, you say 1 room. Does that change if they rent out 2 rooms? And the slide also says 1 room as well. So I'm just curious if that is specific to intentional to focus only on 1 room and it's not.
So if it's 1 room, or if you are renting out multiple rooms, it depends on what your relationship is with the other folks. If you share a kitchen or a bathroom, then you're in that same category. But if you are just, the landlord says, I have this 1 room in this 5-bedroom house that is mine, and everybody else is rented out, then the court's not going to look on that as favorable. Types of fair housing discrimination: intentional, treating someone differently because you mean to. Disparate impact: I made some sort of rule that might not have been meant to treat somebody differently, but because of certain situations or because of certain circumstances that have to do with that person's protected status, it is creating a situation where they are treated differently. Or denying reasonable accommodations for a disability. I'm going to talk about all these. So these are examples of intentional discrimination. Oh, why is the clock behind me? How is that helpful? Okay. I'm trying to get you on time. Refusing to sell, rent your land, discouraging applications. We don't rent to folks here who have kids, for example. Blamed intentional discrimination. Enforcing lease terms differently and responding differently to requests for repairs. So these folks are the folks that I like. And so all of my buddies who are Hispanic are going to get their repairs done first, and then everybody else is going to be ignored. Examples of intentional disability or age discrimination include steering. So this is, well, I think I assume I know what you need, and so I'm going to push you to some particular situation. So I'm going to assume that because you're elderly or disabled, you don't want a top floor unit. You want a ground floor unit. I know this because I assume something about your protected class. And so that could be a method of discrimination. And then of course, other terms or privileges which would only affect them. So no wheelchairs in the lobby, must be able to live independently, would also be things to look out for. Disparate impact is when there's a rule that's created, but you don't necessarily, it doesn't look bad on its face. So for example, a rule that says all tenants have to come to the leasing office every month to pay their rent on the first of the month. Seems pretty simple, not discriminatory on its face. However, if you have folks in the building who you know use motorized wheelchairs and cannot get up the steps to the leasing office every month to pay their rent, and it's creating a situation where it is harming them because of that, then you might have a disparate impact situation. Other examples here, rejection of rental application for bad credit that's related to an abusive partner. So a lot of protections built in from VAWA and for the Violence Against Women Act. So if there are situations that involve those types of abuse of a partner, sexual assault, domestic violence, then those also can be looked at as a parallel to gender discrimination. Reasonable accommodation. This is when you need to change a rule. This is a request. So this is when you need to change a rule, a practice, or a service, so that you're able to equally enjoy the housing. So, for example, in our motorized wheelchair situation, where a tenant is not able to get to the leasing office to pay the rent every month, a reasonable accommodation could be that Mrs. Jones requests that she's able to pay her rent through a drop box on the second floor where she lives, or is able to pay her rent by sending it in the mail, or something like that. It's something which is going to allow a bend in a rule, which is going to help that person equally enjoy their housing. And we'll talk more about what it's not a blanket acceptance of these. We're going to talk more about how to do those in a minute. Here are just some common reasonable accommodation requests. Service animals, caregiver requests. I need someone to come and live with me because I can't open doors and I can't open the cabinets in my home. I need to transfer to a first floor unit because I now have a disability which is making it so I can't walk very well, and this building doesn't have an elevator that I can easily get up and down the stairs. Allowing time to reduce clutter is another one. So this particular person is being kicked out of housing because they're hoarding, and they have a lot of debris all over the house and things like that. And so even at the point where you're going through an unlawful detainer, you can make a reasonable accommodation request saying, we'd like to request more time. We have received a notice. Sorry, maybe we'll go back to notice phase. So we received a notice that said in 30 days this house has to be clean or else it's going to be deemed a nuisance and we're going to move on with the unlawful detainer. But this person can come in and say, well, I have a social worker who's working with me and we'd like reasonable accommodation for 60 days in order to finish cleaning up in order to comply with what you need. So it's that bend in the rule which is going to allow them to enjoy something in their unit that they might not usually be able to enjoy. So here's how one would request a reasonable accommodation, or if you're representing landlords, how they would be coming to you. There are two main pieces to it. One is that bend in the rule, that change. I need this exception, I need this change to the rule because of my disability. Because without it, I can't enjoy what I'm doing. And without it, I'm having difficulty really dealing with my housing situation. The second part, though, is there's a nexus. That means there's something that is meshing together, that disability and the request. And you say what that particular thing is. So you could see how, in the instance of the motorized wheelchair, not being able to get somewhere and putting the rent check in the mail, you can see how those things are kind of connected. However, if you said, well, I'm in a motorized wheelchair, and because of my disability, I need to just not pay rent anymore ever again, is my request. Then that would be a little bit more of a difficult sell, because the landlord would look at that and say, or get the request and say, well, what is this? How are these things connected anyway? And so there must be that connection, and if you can't demonstrate that connection, then that is a fair reason to not grant that accommodation request. Reasonable accommodations do not have to be in writing. They can just be verbal. There's no magic word. They do not have to say a reasonable accommodation. Of course, we always suggest everything be done in writing because we're lawyers and we do that. But there's nothing that necessarily says that they need to do things in a certain particular format. Verification is allowed. The landlord can ask, or the housing provider can ask, can I get some verification of the disability or what's going on, if it's something that's not absolutely apparent. If you are seeing Ms. Jones in her motorized wheelchair every day, asking for some sort of verification that she has a disability is a little ridiculous. But if you're seeing somebody who's requesting an emotional support animal because they get frequent anxiety attacks, and that's not something you normally see or could observe, then you have the right to say, can I get some verification? Now, what you don't have the right to is say, I'm going to need your doctor to give me your diagnoses and letter, a release so I can talk to your doctor about this. The landlord does not get to know what's going on diagnosis-wise. There just needs to be a letter from a doctor or any independent third party which says, this person has a disability, so it could be a social worker, case manager who they're working with, this person has a disability, and they need this particular accommodation in order to assist with their disability. The next part to this is reasonable modification. A reasonable modification is like a reasonable accommodation, except that you are asking for something that is structurally added to the building. For example, I need a wheelchair ramp in front of my home. I need grab bars on the sides of the toilet. Things like that are structural changes would need to be made to the housing itself. And the difference between a reasonable accommodation and reasonable modification from the perspective of the requester is who pays for it. Reasonable accommodations are for the most part paid for by the landlord. So, or they will foot the bill for whatever the accommodation is. Reasonable modifications, on the other hand, will be paid for by the tenant. So the landlord's responsibility would be to say, yes, we can allow for that. We can have a contractor come in and look at how to do a ramp in front of your unit. But in terms of footing the bill for how that's going to happen, the tenant would be responsible for that. Only exceptions if it's a HUD-funded tenancy. So if you are in subsidized housing, if you are in public housing, for example, then any of those modifications would be paid for by the housing provider. Reasonable accommodations and evictions. Just a note to say that you can request a reasonable accommodation at any point of a housing relationship. So from the very beginning of advertising to you don't even really have a relationship yet, you're just kind of dating, all the way through to we have this horrible relationship and now this relationship is going to end. This can be requested at any step of the way. So it can be to the point where you are ready to go out the door and the relationship is ending and a reasonable accommodation can be made at that point. For example, I'm not able to move out. I'm supposed to move out by court order tomorrow, but I just got out of the hospital yesterday and I've been in there for a week and I have now breathing equipment and I'm going to need a few days. So making that request can happen at that point. So what is reasonable? From the perspective of a landlord, when can I see a few of you laughing at that a little bit? Yeah, exactly. So it has to not be an undue financial burden. So I am going to need you to install a brand new aquarium in my home. Forget it, I can't figure out the disability that relates to. But for a barn for my miniature horse is going to need to happen in my unit. Then that could be something that is just too expensive for the landlord to have to comply with. Additionally, and not an undue administrative burden. So something that really is going to make the office have to do a ton of work to have to comply with every month or whatever it is something they can look at as well. Now, important to note that in California, these two things are put together. So you have to have an undue financial burden and an administrative burden together under California law. HUD, with the federal laws, Federal Housing Act, it is an or, California it is an and. The next one is it does not change the nature of a provider's operation. So for example, I have a disability which does not allow me to drive a car, but I need to get groceries, so I need the property manager to go get groceries for me. Well, that's a great accommodation, but we're not in the business of delivering groceries, we're in the business of providing housing. And so as much as we'd like to accommodate you, it's going to change the nature of what we do, the basis of our work, and so that's not something that we're going to be able to accommodate. Additionally, the use of illegal controlled substances is also something which is not going to be allowed, and conviction for manufacture or distribution of controlled substance. You cannot say that I need a reasonable accommodation to grow my pot farm and it's hydroponics on the second floor, because that would be in violation of illegal controlled substances in manufacture. Additionally, direct threat to the health or safety of others. So if whatever accommodation you might want to be bringing in, I need to be breeding cobras in my home right next to the third graders who live next door, then clearly I need to come up with some better examples, but those could be a direct threat to the person. Or I need to have someone come stay with me. I need to have my son-in-law needs to come and be in my house because I need him to help take care of me. But this person is known to frequently commit crimes at the property and carry guns around the property, then that could be seen as a direct threat too. And so those are things that that housing provider might want to look at. Okay. Any questions about that? We'll move on to evictions. Yes?
The California, you said that something can undo financial burden in California, and they both have to apply.
Yes.
Well, let's take your example of your miniature horse farm, a barn.
Mm-hmm.
So if it's according to California law, the owner to build the farm because there's no barn, because there is no administrative burden?
According to California law, the owner would want to make the argument that not only is the miniature horse barn a financial burden, but having to take care of it and having to get the plans from the permit from the departments and the city, and all of that is administratively burdensome. So yes, they would want to make both of those arguments at the time. They say,
But if they can't make the administrative burden, it's just a matter it's gonna cost them another $10,000 to put in a barn?
yeah, then they would want to say, well, this is actually a reasonable modification and you pay for it. So this is what lawyers do.
Okay.
Right? But yes, absolutely right that in California, you're going to want to say financial burden and administrative burden. So looking at both of those two things and not just saying, oh, it's going to cost a lot of money, but saying it's going to cost money and it's going to cost staff time, or it's going to cost some other administrative resource that we have. Okay, we good? Okay, so moving on to evictions. Unlawful detainer is the name for eviction in California. I don't know why. Commissioner, do you know why? It's a weird thing. I'm not exactly sure why. But we call them unlawful detainers, and that means you're being kicked out of your housing. And so there are several types of evictions that we want to talk about, several types of notices which somebody could get in the state of California. Commissioner?
Actually, the reason they're called unlawful detainers is that you cannot, and it explains about why notices are involved. Because the landlord can't evict somebody or kick somebody out of their property until the property is being detained from the owner illegally, unlawfully. And so it isn't unlawful until the time when a notice has run. It isn't unlawful until some contingency has been taken care of. So that explains why there's no jurisdiction for the court until the tenancy becomes unlawful.
That's fantastic. Did everybody hear that?
Mm-hmm.
Okay, that's going to make more sense as we go through what the timeline is for unlawful detainers. But basically, unlawful detainer is the lawsuit, right? And before the lawsuit can happen, there has to be a notice period, and that notice has to not have been complied with. So what the commissioner was saying is that during that notice period, if that notice period has not expired, the court doesn't have jurisdiction because there's no unlawful detainer yet. And it's only when that unlawful detainer has happened that you can move forward with the court. Did I get that right?
Yep.
Right? Okay, fantastic. So two different types of unlawful detainer notices that you are going to see. One is called for cause and one is no cause. Now this is very different than it was in December, because in December we had different laws which said that you could evict somebody for with a 30-day notice or a 60-day notice for no reason at all. So if they lived in the place and they've been there less than a year, then you could give them a 30-day notice for no reason and say, I'd like you to move out in 30 days. And if you don't, we're moving on to unlawful detainer. And the 60 days is for if you live there for longer than a year. Well, the state of California decided that they don't want to do that anymore, and now we have something called just cause for eviction, which we'll talk about in a second. So for right now, this is what the chart looks like. With for cause, there are two reasons. One is at fault. The tenant did something that is causing them to be, or the tenant did something which has disrupted the relationship between the tenant and the landlord, which is going to cause a notice to be issued for that unlawful detainer. And no fault is the landlord or the housing provider has done something where they are going to need that unit back, but it doesn't necessarily have to do with something that the tenant did wrong. So for example, I need the unit back because my mother-in-law is going to come live with us and she needs somewhere to be. On the other side, we have no cause. And this is really now only the folks who are exempt from the just cause provisions, who we'll talk about in a little bit, and folks who have been renting for less than a year. The state's just cause provisions only kick in if you've been there 12 months. I should say with the caveat that there are a bunch of local jurisdiction rent control and just cause ordinances that are coming in. So whoever has the strongest protection for the tenant, that's the law that is going to supersede. That's the one that's going to control. Yeah?
Can the tenant waive the just cause requirements in a lease agreement?
No. It is specifically written into the law that they are not allowed to waive it. There is a no waiver clause in the law. So this is the unlawful detainer flowchart. This is what it looks like the entire process from beginning to end. The unlawful detainer is a summary proceeding, which means unlike a lot of the proceedings that a lot of folks in here practice, where you may be in court and have the same case for a year, 2 years, 4 years, unlawful detainer, everything happens really in one trial, one proceeding, right? One appearance before the commissioner. He's going to see you that one time. So it really is a very, very short timeline for the way that everything happens. So let me just walk you through a little bit about how this happens. So first, you get this notice, the pre-unlawful detainer paper that says something is going to end the relationship between landlord and tenant via tenant fault or landlord initiated. And then after that notice expires, say the tenant got a notice to pay rent or quit. You have 3 days to pay the rent that you didn't pay for this month, and if you don't pay it, then we're going to move on to unlawful detainer. After those 3 days are completed, the sheriff cannot come and lock anybody out. The landlord may not come and change the locks. What has to happen is it moves on to this court process. The only thing the landlord can do is then file this unlawful detainer paperwork. So they file unlawful detainer, say rent has not been paid. Day number 4, no rent. Okay, I'm going to go file this unlawful detainer paperwork at court, and I'm going to have someone serve it on the tenant to make sure that they properly are aware of what's going on here. It used to be that the tenant had 5 calendar days to respond to this. As of January 1st, it is now 5 court days. So Saturday, Sunday, court holidays no longer count. So if, for example, I'm going to receive this summons and complaint on a Monday, get it Monday, that doesn't count. So Tuesday, Wednesday, Thursday, Friday, but then Saturday would not count, Sunday would not count. My last day to file a response would be that following Monday, unless it's a court holiday, then you have until that Tuesday. Now there are 2 options here, and this is where it really opens up and can make a difference. It really depends on whether or not a response is filed to that initial paperwork. Now most folks are used to in California, they receive court paperwork, you have 30 days to respond to that. You have longer to respond to that. You have time to go figure out what's going on. But really, and no one reads that front page of the summons that literally says on the first line, you have 5 days to respond. Nobody reads that. So if a response is filed, and that can be an answer, it can be a demur, it can be a motion to quash, any of those things, then we have a longer timeline that's going to open up here on the side that's going to lead to trial. After that, you get a notice of the trial, it's sent by the court. The landlord's going to have to file something that says, I'd like a court trial, please. The court sends out a letter that says, here's when it is. And then there's a trial. If the tenant and landlord go to trial and the tenant loses, then there's going to be about 5 to 7 days of notice to vacate, which is stuck on their door, and then the sheriffs will come out 5 to 7 days after that. So you're looking at a timeline of about 3 to 4 weeks in here. If they win, then they have to pay back that rent and they have to stay. And they can stay, I should say. So for example, they went to trial and said, well, actually, no, I didn't owe the full amount of rent for that month that you say I didn't pay. I only owed half of that because I paid half. And the judge says, okay, well, in that case, you're right. The notice was defective. It was incorrect. And so you're going to win this case. The tenant still has to pay back that other half of the rent. Whatever the judge says is owed at that point needs to be paid back. And so that is oftentimes, for both parties, they might not actually want to get to this point because it might not get them what they're looking for. So we encourage a lot of discussion, a lot of settlement, a lot of mediation to try to get folks to get what they need and to preserve the relationship, especially if they're planning to move forward. Now on the other side, if a response is not filed within those 5 days, day number 6, the plaintiff or the landlord can go in and file a default judgment. So they can go in and say no one has responded, and since no one has responded, we win. And then they would serve that on the tenants, and then after that we get to the same notice to vacate stage that we have all the way down here, which is when the sheriff goes and puts a big piece of paper on your door with a black star that says we are coming out in 5 days to lock you out. And then the lockout will happen after that. So the question is, how many days notice does someone have to get? So we get the whole 5 days after unlawful detainer you have to answer. The whole process might take a month, or it could be really quick if they don't answer at all. But what does that notice look like? And to answer that question, we have to look at what type of tenant we have and what type of notice we have. And I'll explain what that means. For example, you have a notice to pay rent or to perform a covenant or quit. Perform covenant just means you promise to do something, like you promise to abide by your lease terms. Your lease said that you are not allowed to keep any AK-47s in your front lawn, and your display of AK-47s in your front lawn has violated this lease term. So that, or pay rent or quit, would be a type of notice that a type of tenant could receive. So how many days does that tenant get to cure that notice? Cure the notice means they fix that particular thing. Some notices are curable, some notices are not. In this instance, you can cure a pay or rent or quit. You can pay the rent within those 3 days, and that will cure the situation, and you can continue on with your relationship. Private landlord-tenant, you're going to get 3 days. But if you have a subsidy, so for example, Section 8 voucher holder, you're in public housing, you're in project-based Section 8 housing, then the number of days that you're going to get are going to go a little bigger. Actually, sorry, Section 8 voucher holder, also 3 days for this. But with these ones, project-based Section 8, LIHTC housing, which is low-income tax credit housing, or public housing, there's going to be a few more days that are allocated in there. And that's attached to the type of housing, the type of subsidy that they get. Notice to quit. You did something illegal, there's nuisance, breach of lease, those types of things. Type of tenant, private landlord or Section 8 is going to be 3 days. Other subsidies are going to get more days than that. There's no reason you have to memorize exactly how many days everybody gets. But just in the back of your mind, if someone comes in and they say, well, I'm in public housing and I got this notice, I want you to go, okay, there's a subsidy there. This may be something to look into if they might need a longer notice term than they actually have. Because remember, if that notice is defective, if there's a problem, then that's going to kill the entire process and they're going to have to start over again. Oh, that's exactly what I said. So then the defective notice is an illegal notice. If the notice does not have the correct number of days, does not follow the statutory requirements, then even if it conveys the information, if it doesn't do so in the form required, then it cannot be a basis for the unlawful detainer. The court has no jurisdiction, and Commissioner Richards is going to tell you to go back to start. So we want to make sure that those notices are correct from the get-go, so that a property manager or landlord who's going through the process is like, okay, I'm ready to file the unlawful detainer, doesn't get a rude shock that all of a sudden they have to start at the very beginning. So this is where I'm going to request that we send out the slides because it's about that big on your sheet and very possible to see. Yeah.
With respect to the defective notice, is there a place in the flow chart where that issue has to be raised, or could it be sort of sprung at the last minute, before the sheriff is about to come kick you out?
Ah, okay, good point. And the answer is not at the very end when the sheriff is about to kick you out. However, when you raise this can be a matter of strategy. You can tell I'm talking to the lawyers in the group. So there are a couple of times when you can raise this, right? Number one is someone comes into you and they say, I have this notice. And you say, that notice doesn't look very good. I think this is defective. Maybe we should communicate with your landlord and let him know that this is not something that is going to work. Right? That's one time you can raise it, right? Another time you can raise it is you can say, this isn't going to work, and I know it's not going to work, and if the landlord doesn't figure out it's going to work and they bring it to trial, then I can go to trial and say, excuse me, this doesn't work, and it's not my job to be, as the tenant, to be that landlord's attorney. Those are the two main places that you would raise it. Once there is a judgment, so say you went down over here and there's a default judgment, it doesn't matter if that notice was written in crayon. It's going to be very difficult to go backwards. So you want to make sure that you raise it before the trial comes up, and that usually happens in that prior to anything being filed phase, or when the unlawful detainer is filed, you can then say, we're going to file a demur to say that this is not something that can be, there's a problem with the pleading on its face because the notice is defective. And then you can also wait till trial and raise it at trial. And then the judge looks at you like, well, why didn't you say this before? Like, really, come on. But, so there are different times when you can do it, but you want to make sure you do it before you get to judgment. Yeah.
Since we have Commissioner Richards here, why don't we ask him the question? Because as an attorney for strategy, a tenant's attorney, you want to spring it at the last moment. So the question is whether that defective notice has to be whether it has to be proven as a case in chief with a landlord, or does it have to be raised as affirmative defense? My position as an attorney for a tenant at times, I think the landlord has to prove it in their case in chief that they properly served the notice. So, as a tenant's attorney, you want to wait to the very last minute. You do not want to include the landlord's counsel in, because you can buy your client up perhaps a month.
Right, so Commissioner?
Well, that's correct. Since service of the notice is jurisdictional, you can actually raise it even after the court's made a judgment. You can raise it 2 years after the judgment was made and get the case set aside because the court originally didn't have jurisdiction to bear it in the first place.
That's even better.
That's even better. Except you're ready.
If we're in the business of advising tenants, keep in mind that they still have to pay the rent during all of this time. And many times if you let them delay and delay and delay, they spend the money for something else. They can't pay the rent when they do win the case and they're out anyway.
Right, right. So there are bigger problems that kind of come down the line. But just to capture what that conversation really quickly, because that is important, what we were just talking about is the strategy of you could wait until, trial to say, oh, the notice is defective, to really stretch it out as long as you possibly could. Or as Commissioner Richards was saying, you can even go after you have a judgment and ask for that motion, make a motion to set aside the judgment based on the fact that there was no jurisdiction in the first place to hear the case. That being said, if you are after judgment and you are after lockout, you can get a motion to set aside the case that will not get the tenant back into the property. So best to do it while possession is still an issue and that tenant is still living in the place. Because after the person is completely out, even if the motion to set aside takes the eviction off their record, it is not going to get them back in the door. Sir?
So, I'm just the banker guy asking another question. You go through this process, the notice of default defective notice was rendered late in the process. When is the tenant required to make a payment? And you said they have to pay. If this goes past your process and it's been 6 months, 9 months, and it has to start all over, when does the tenant have to make a payment?
When do they have to make a payment?
Yeah.
So the tenant had to make the payment during the notice period anyway.
If he
Right.
doesn't do it.
So-
If they make a payment, it just stops.
Yes.
Right, so they're not paying. At what point does the tenant actually have to provide good funds for the full amount past due?
You want to answer it, or you want me to?
I mean, I'd love for you to, but let me answer and then you can tell me if I mess it up. So, while the tenant's supposed to pay during that notice period, when that landlord can actually collect is when they get that judgment. Because the court's gonna be the one to say what that amount is.
You
So-
just said if the judgments could be set aside?
You can set aside the judgment, yes.
Keep in mind that it depends on factors of both sides, the landlord. Within the 3 days, the landlord, if it's offered, has to accept it. But the landlord only has to accept the full amount, can reject any partial amount. After the 3 days is run, the tenant can offer it, but the landlord's not required to accept it. They can go forward with the unlawful detainer. After there's a judgment, it's enforceable like any other judgment. When is it payable? When the landlord can squeeze it out of them.
I think
Enter entire separate training on collections.
I think what's underlying question is, and the answer is if the person raises the issue of the jurisdiction at trial, the answer is that the rent continued to be due and accruing during that period. If they raise that issue and the tenant has not brought the rent current, the landlord is immediately going to serve another 3-day notice for the full amount outstanding and due the next day. Generally get the 3-day notice correct at that
Right.
point. Generally. Sometimes it takes them a few times to get them right. And then bring the action again. So they have to start over.
But the tenant can pay full.
The
but
tenant
they
can
get
pay
the
full.
service.
Yes.
No.
The tenant will be
Right.
able to cure the
But
second time as well.
realistically speaking, at that point, the tenant never pays in full. They've spent the money on something else.
Hey, in the back.
Just one thing to your point about just when to spring it. If one thing to keep in mind is that if the lease has a provision for attorney's fees, the prevailing party will get attorney's fees. But if the landlord is tipped off that the notice is defective and they voluntarily dismiss it, that's not a prevailing party, because that doesn't make the tenant the prevailing party because it's dismissed before trial. So that is just one thing. I mean, there are exceptions to that, and then there's the, I was just doing research on it, I'm forgetting the language. But that's just like one other thing to consider is are attorney's fees something that are being contemplated? And if they are, what is a prevailing party? Is it if there's a demur granted without leave to amend? Possibly. But if it's just, oh, we're having an informal discussion and now I've been tipped off that it's defective and the landlord says, okay, I'm just gonna dismiss it and start over, that's not a prevailing party, so they're
Okay, yes, so
something to consider.
strategy in terms of when to attack a notice, how to attack a notice, if to take into consideration attorney's fees. I leave to all you brilliant minds to figure out how you want to do that. I will tell you procedurally what can happen at a couple of these different stages. So we are just talking about the motion to set aside, which can happen after a default is entered, after you get a judgment at any point. So you can go in and say, for example, I was never served the unlawful detainer, and so I need to file a motion to set aside the judgment based on non-service. So that could be something that people are coming in with. We have folks who are coming into the clinics at all points of this process. Some of them just have a notice. Some of them come in with the notice to vacate from the sheriff and say, I don't know what happened. I don't know what this is. I was never served. Some people went to trial and they lost. Some people went to trial and they won, and they don't know what was going on. So there are a lot of different things that can be done on either side. The parts in orange over here, and like I said, this is where I'm going to ask the bar to please send around these slides, because I know it's about that big on the paper in front of you. The orange ones over here are actions that can be taken by the landlord or the landlord's attorney. So for example, when the default is entered, they're going to have to be the ones to file that judgment and file for the writ of execution and get the sheriff moving to go out there. The sheriff doesn't automatically know that they need to go out and perform a lockout. There are other papers that need to be filed. The blue ones on the other side are things that can happen for the tenant. So for example, a stay of execution. A stay of execution happens When you have the notice to vacate saying everything's all over, judgment has been rendered, you lost, you need to move out, and the sheriff is going to come out in 5 days, so please take all of your belongings and pets and everything out of the house with you. And you say, well, geez, there's something, I really can't move out in that amount of time. So is there anything I can do? And the answer is yes, maybe. So the stay of execution allows for a tenant to petition for more time to stay, and they need to have two things. Number one is they need to have the rent that would cover the amount of time that they want to stay. So for example, their rent is $1,000 a month. They want to stay an extra 15 days. They're going to need to have that $500 upfront paid to the court before anything else happens. Now this is not on top of paying any other things that they might have due. So this goes to the court and must be paid upfront. So no money, no stay. That's number one. Number two is there has to be some sort of hardship. There's got to be a reason why you cannot move out in that time, and it's going to be something very difficult for you. So for example, like I said before, I've been in the hospital, or my husband's been in the hospital for the past 2 weeks, and I've been unable to pack, and I just need 3 more days in order to be able to get everything together and get my kids to get the moving van and get out. So you're not really making any arguments of law in terms of whether or not you should have a right to stay. This is an emotional appeal saying, I have a hardship and I can pay the money. If I give you the money, will you give me these extra days to stay? And the court will then make that decision based on if any opposition is rendered by the other side of whether or not to allow that stay to happen. Then if the money is paid to the court, it's a non-refundable bond. If that money is paid to the court, then that can happen. And if they fail to pay that, then the stay will not go through. Yeah.
Yeah, the money paid to the court, but we all have to understand it's a very long time before the landlord actually receives that money.
Yes, that's right. It will take quite a bit before the landlord actually goes through, because it goes and sits in the court's coffers somewhere, and then of course the landlord needs to figure out how to recover that. So it is the landlord's money, but when it actually transpires through that, I think it's what, 60 days now?
Well,
That's
by
gonna
that time, the
take?
landlord has lost the property for closure, because they
So-
couldn't make the mortgage payments.
Thank you, Jim.
So yeah, I mean, depending on how.
It happened to me last week, okay?
Okay, so yeah, I mean, that's one thing to consider as well. And that's also why if you have someone who writes a stay that says, well, I have an emotional hardship and I need another 80 days in order to do this, then Commissioner Richards is already laughing, right? Because then the commissioner is going to say, well, that's going to be a real hardship on the landlord in terms of when they're going to get that money, in terms of when they're going to be able to move forward with renting this place to someone else and continue a new relationship. And so those are things that are going to be balanced.
One other thing that's not in there, and that is that when it gets to court and before trial, there are mediators there in our courts in this county. And one of the other options to have to do with notice is you bring it up in mediation. And the reason to do that would be if it isn't found to be invalid, the case starts over with a new notice and so forth. All that payment has to be made, but it can be resolved in a compromise in mediation where the case is dismissed. You arrange with the landlord to pay some amount or no amount or whatever, and you can solve the problem for the tenant and the landlord in mediation.
Absolutely. So in Commissioner Richards' courtroom, he will say to everybody assemble, I've been there.
Not anymore.
He used to say it, everybody assembled. And hopefully the new recruits are doing that as well.
We have the new commissioner here as well.
One of them.
Oh, okay, so you can tell me then if the new commissioner, if this is true, because Commissioner Richards used to say to us, as soon as everybody was assembled, there are mediators here. They can help you work this out. That you can go into that room. They are free, and you can talk to them to figure out if you can come up with something. Sometimes it doesn't help the tenant to win a case because they don't have the money to pay it back anyway. So if they can come up with some other situation which is going to allow for a solution that may not be reachable by the court, then that's something that we always encourage folks to try to do. Commissioner, does that sound about right?
Yeah, we do. I work in Richmond, so I know in Pittsburgh they have more mediators. In Richmond, we now have one that just started like 3 weeks ago. And so that's been great. Unfortunately, she got the flu because it's that time of year, but she's wonderful. And the first cases that she mediated, she came in and she said, people are so polite in Contra Costa County. She's from San Francisco. I didn't know what the reference meant, but I thought it was funny anyway. But she's great. And a lot of our attorneys will also meet with the tenants and the ones that come in Richmond. We always encourage discussions and, but yeah, now that we have mediators, I'm thrilled because it's the best, especially when the pro per tenant realizes this isn't someone that's gonna represent the landlord. This is somebody who's completely neutral. They feel more secure, less frightened, especially when a lawyer is on the other side for the landlord. So yeah, if I could have mediators every day, I would.
Okay.
I just want to thank our commissioners for plugging in the mediation. I'm with Couples of Neutrals. We provide the mediators, volunteer mediators, and thank you to our 2 volunteer mediators that are here. I was going to do a plug at the end, and I'll still do it, but we're always looking for more mediators. Especially in Richmond, we were short, so I apologize.
Oh, no,
We're working on it, but we always try to have a mediator there. And just for the reason the commissioner mentioned, that it works, especially with pro per parties, mediation really works. So I can talk about that more at the end, so we'll let you continue.
Yeah, sure. I'd love to go to a mediation training as well. I mean,
Well, let's
part
talk.
of what we do is we let people know when they're in this, okay, so now that we're going to file a response for you, it's going to open up this side of the flow chart, and you have this amount of time, 3 to 4 weeks before you go to trial, and there's a lot of things that you can do during that time. And you don't only have to be gathering all your evidence to preparing for trial, you can start thinking about if you want to preserve this relationship that you have with your landlord. If you want to stay there, going and fighting with somebody in court might not be the best way to remain friends. So we say maybe there are other ways that you can resolve this, and let's talk about maybe thinking about a way that it can be settled, or let's talk about, we try not to wait till the last minute and say, okay, all right, if you can't figure this out, there are mediators at the court that you can figure this out with, but we encourage them to think about it ahead of time. What types of things would you be willing to say, I'm going to compromise on this in order to make this relationship work? So if they're not able to figure it out before they get to trial, at least when they get to the mediators, they're thinking in that way. Because we want to get them out of the mindset of going to trial, win or lose, is going to get you exactly what you want. But we want to make sure that they're going in fully prepared, knowing even if you have a defective notice, you could be turned around the very next day and a new notice can be given to you and you do owe that money. So let's think about what we can do to deal with the entire situation, not just to look at the paperwork as black and white. Okay, so just cause and rent control. Not bad. I apologize ahead of time for just cause and rent control. So we're talking about the Tenant Protection Act of 2019. You might have heard of this as AB 1482. And this is just cause and rent control for the entire state of California. It was passed in 2019, became effective on January 1st. And Section 2 talks about just cause. Section 3 talks about the rent control part. Section 1 just says, yay, this is the name of the bill. So this applies when you have 12 months continuous and lawful occupation of the property. Now, if there's more than one person in the property, then somebody's got to have been there for at least 24 months. So if you have folks moving in and out, and 7 months, your friend comes in, and then your girlfriend crashes 12 months later, or whatever it is, someone's got to be there for that amount of time in order for that to happen. But with your basic one-on-one tenancy, you're looking at 12 months of continuous and lawful occupation. And then it needs to not be subject to an exception, which is the big but. So we're going to talk first about exceptions, because I hate it when I learn all about a law just to figure out it applies to nobody. So let's talk about who this does not apply to. When you're thinking about hotels, nonprofit hospitals, things where your stay is extremely short, for example, or you're not intending to live there for a long time, dormitories or schools, when you're dealing with, I said this before, the tenant sharing a bathroom or kitchen with an owner who lives at the property. So this can happen in several ways. This can happen in, we own a 4-bedroom home, and I, as the landlord, am renting to somebody and we share a kitchen together. Or it can be there's an accessory dwelling unit and that's connected to the home, or the home is configured in a strange way where we each have our own areas, but we're still sharing one of those particular things in common. Single-family owner-occupied residence, including that, ADU is accessory dwelling units, if not more than 2 rooms in the ADU are rented. A duplex with the owner in one house, so that's kind of a twist on this other side of having somebody else there. And new housing which has been built 15 years ago or more recently, and that will continue to roll. And then the big one is single-family homes, which encompasses a lot of what we have in California. And so this is what you want to look out for. The Tenant Protection Act does not apply to single-family homes if 2 things happen. Number 1, the owner is not a real estate investment trust, a corporation, or an LLC with a corporate member. Right? Essentially, it's not owned by a corporation in some way. And number 2, the tenants need to be provided written notice that just cause does not apply to them. So this is the actual language which needs to be given to the tenants. It actually has to be that language. And it just says, blah, 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 this property is not subject to rent control. And this language can either be in a lease, or it can be given, in a letter that's going forward. So right now, what a lot of landlords are doing is they're writing a letter and they're delivering that to the tenants. Come July, it's going to have to be in all the new leases. So folks will know from the get-go, this is something that's not covered. Government subsidized housing. So again, your public housing, your project-based Section 8, those types of things that would not apply to as well because they have their own rules on how they move people in and out. And then a more protective local ordinance exists. So for example, we have a Richmond rent ordinance, which is actually very protective and has some parts which are more protective than the state ordinance. In that case, you would choose the Richmond rent ordinance, you would not choose, the tenant would choose the Richmond ordinance if it protects them more, but the landlord wouldn't necessarily have a choice there. It is whatever is more protective of the tenant is the one that's going to apply. Here is that little thing that says you cannot waive it. It's written in there, so even if the landlord were to give the new lease to a tenant that says, here's all the language, we live in an apartment building, but you're going to give me $200 and you're going to waive the just cause provisions that would be applicable to you under state law, then that cannot be enforced. So I'll talk a little bit about the at-fault just causes. So we're thinking about apartment buildings. For example, you have your multi-story, multi-unit apartment building where you have a property manager. That's kind of generally unsubsidized. Those are generally the situations that we're looking at here. And these are the different reasons that would be these at-fault just causes. Remember, they're the at-faults and the no-faults, right? So these are the ones where the tenant did something which harms the relationship between that tenant and landlord, which would be a just cause for giving them a notice of eviction. Number 1 is always going to be rent. You don't pay the rent, you get a notice. That's number 1 always, and this is under all of the rent ordinances that I've seen. Number 2 is a breach of the material term of the lease. So the lease says that you are not allowed to have any dogs in this building, aside for support animals, who are, by the way, not considered dogs and pets anymore. They become a brand new breed of brand new species called support animal, who pet rules and things do not apply to. So, breach of material term of lease, you are not allowed to have pets and you have a tiger that is living in your home, and so we're, that is harming our relationship because you failed to comply with the promise that you made in your lease not to do that. Nuisance, you are conducting, you have a sriracha factory going on in your house and you are cooking lots of chili peppers and onions and everything at all hours of the day and night, and everybody else's eyes are watering and it's hurting, and that's becoming a problem for your neighbors. Waste is basically you're just destroying things. You have We noticed that your entire back fence has been rotted out because you are keeping a whole bunch of stacked up, decaying things. Whole bunch of nastiness hanging out in the backyard that's creating something which is destroying part of the property. Refusal to execute a written extension or renewal of the lease of similar duration with similar provisions. So this is, our lease expired, we're now month to month, we finished our year, right? And the only thing that happens at the end of that lease that we signed is, now we're month to month tenancies. So we still abide by the same rules, but now we're just month to month and we're not within a lease term. So the landlord can say, well, I'd like you to execute a new lease, so we have a new year going, and we know what our relationship is like. If there is similar duration with similar provisions, then they can say, yeah, well, you have to sign this lease. But if they're going to come in and say, we're going to execute a completely different lease here where you're going to pay $2,000 a month for your parking space, that could be something completely different. And then they might be, the tenant's going to say, well, no, I'd like to continue under the old lease that we have. Thank you very much. Criminal activity on the residential real property. The on is the important thing here. Criminal threat on or off the property if it has to do with the agent of the property. So, for example, tenant and property manager don't get along very well, and they meet at a Safeway one evening. And they get into an altercation, and tenant decides that they're going to threaten the property manager at that Safeway in a criminal way. Or they slash the property manager's tires in the Safeway parking lot. That is not criminal activity that happened on the residential property, but because of the person it happened to, that is something which can be a just cause for eviction. Assigning or subletting, but only in violation of the lease. A lot of folks think, oh, well, they're subletting and they're illegally subletting. Well, they're only legally subletting if you said they can't do it. So it has to be in the lease, and it has to be something they said they cannot actually do. Refusing entry to the owner as properly authorized. So there are only certain times that a landlord can just go into a property. One is to make repairs that are agreed upon repairs between the tenant and the landlord, and they have to give 24 hours written notice. Another is to show the property to prospective buyers, renters, whatever. Again, they have to give a certain amount of written notice. And so if they've done what they need to do and jump through these hoops to say this is what I'm coming in for this lawful reason, and the tenant still says, no, you can't come in here, I'm completely blocking you off, the landlord can say, yeah, but your sink is leaking so much, the water is coming out the doors, and I need to fix this before it affects the entire complex, then that could also be a reason for just cause for eviction. Using the premises for an unlawful purpose, meth lab in the bathroom. Employee, agent, or licensee fails to vacate after termination. So I am working as a property manager and I live on the premises. However, I have completed my work, I'm not working there anymore, I've taken on a new job, and part of my arrangement was that I was going to be able to live at this complex while I work there. Now that I don't work there, I've got to get out. And if I fail to, then that is also a just cause. And then the last is the tenant provides a written notice and doesn't leave. This is a big one because tenants don't realize that when they give that 30-day notice saying, I'm going to leave, that's something that they can be held responsible for. And so they say, well, I gave a 30-day written notice, but now we're on day 28 and I don't think I want to go anymore. Well, that's quite unfair to the landlord who's now had to make preparations for what's going to happen next with your unit. And so that is a reason. Also, the landlord can then take that notice, that 30-day notice issued by the tenant, and use that as the notice that would accompany the unlawful detainer. So here are the no-fault just causes. So not the tenant did something wrong, landlord has decided they want to end the relationship, and here are a couple of reasons they might do that. Number one is owner moving. Now this can happen only with certain folks, but this is, I need the unit back because I need to move somebody in who's either me or someone who's closely related to me. So in California, it's your spouse or domestic partner, your parents, your grandparents, your children, and your grandchildren. So 2 up, 2 down. grandma's coming to live with us, we need this space for her, and so I'm gonna have to ask you to leave, and I'm going to give you a notice, and we're going to follow the appropriate procedures to move along with that. Withdrawal from the rental market. I don't wanna be a landlord anymore, I'm gonna put this thing up for sale, and so you're gonna have to leave so that this is no longer a rental unit. Government agency or court orders requires vacating. So this place has been red tagged, and you cannot live here anymore because it is not safe, it is completely falling apart, the only thing holding it together is termites holding hands, and so we cannot continue to allow you to live here. Intent to demolish or substantially remodel. So if there is a permit or an abatement of hazardous materials which cannot be done safely with the tenant in place, then you can issue that notice. Now, there are things that come along with this, so there's a part 2. Hold on to this for a second. So the procedure, I don't know why the part 2 is not right behind that, but anyway. The part 2 of that is that there may be relocation payments that come into play. And so, and I know I have slides on, so I won't talk too much about it, but if you have a no fault, no cause eviction, you're going to issue one of these notices for owner move-in, for example, then you may have to pay that tenant relocation payments. And in the state of California is a month of rent, but if you have something that's more restrictive, say for example in Richmond, they have a whole schedule, you're going to pay depending on how many bedrooms. So for say a 2-bedroom apartment that you're moving a family out for owner move-in, it's about $8,500. Here's the procedure. If curable, a notice of violation must happen first. So guess what? This is a notice before the notice. Remember the notice we talked about? Now there's another notice. There's another notice that's got to happen before this notice happens, before the unlawful detainer can happen. So this notice has to happen if it's something that's curable, meaning it's something that can be fixed. So it's not a, you shot 3 people on the premises last night because you can't fix that, as far as I know. It's more of the, I've got a dog and you shouldn't have a dog situation. And then after that is when you can get that notice to terminate. So this would be the 3-day notice to perform covenant or quit, or any of those things that we talked about before. Here we go. This is where we talk about relocation assistance. So it is either 1 month of rent provided within 15 calendar days notice, or you waive in writing the final month's rent before it is due. The landlord gets to elect which one they want to choose. So they can either say, I'm writing you a check for 1 month versus rent and you're going to get out, or they can say, well, we're into February right now, March is coming up, I'm going to waive the rent for March, and that's going to satisfy your relocation payment.
I have a question.
Yeah.
If a landlord were to do that, and then the tenant after that month decides not to move,
Yeah, that sucks. So
well, he's accepted not having to pay that rent. So in essence, I think he's agreeing that it's a termination of the lease. But if they don't move,
So if they don't move, right, then all of a sudden they've breached a term of the agreement, right? That is no longer a no fault. Now we're moving into the tenant's fault side. And when you're on the tenant's fault side, then no relocation payment has to be paid. So then normally what would happen, or what we're seeing happen, because there's no normal yet,
you don't have to give it to him twice.
and you can sue them to get it back.
Good luck.
Again, good luck. Yeah, exactly. Enter whole new training on collecting against tenants. So this is a page from the Richmond Rent Board's website. The Richmond Rent Board has a very robust website with a lot of materials about their rent ordinance. So if you're going to practice in Richmond or volunteer with us in Richmond, then I suggest you take a look at that. This chart just divides up who's fully covered for rent control and just cause, who is only partially covered, meaning it's only just cause, and who's fully exempt, meaning rent control and just cause do not apply at all. So in Richmond, property enrollment is required for all of these properties. So the very first thing that has to happen is the landlord needs to enroll that property with the rent board. Not enrolling the property with the rent board is a complete defense to an unlawful detainer. So you can have everything going right with your notice, but then if the tenant finds out you haven't enrolled, and they can get something from the rent board that says this property is not properly enrolled the way it should be, then that unlawful detainer cannot go on until that enrollment has happened. So here, fully covered would be properties with more than one dwelling unit on the parcel who are built before February 1, 1995. So unlike the state that has 15 years that's going to keep moving, this is stuck at 1995. Partially covered, meaning only just cause for eviction, government subsidized units, single family homes, condominiums, new construction, permitted small second dwelling units, it's those ADUs again. And so those just cause would work, but there would be no rent control, which would come into play. And we're going to talk about state rent control in a second. And then fully exempt, meaning nobody, there's no just cause and no rent control in Richmond, would be tenancies where the tenant and landlord share the kitchen or bathroom. They've heard that before. Permitted second dwelling units where the owner occupies the single family home on the parcel. So the owner occupies the main house and is renting out that permitted second garage or little unit in the back, granny unit. And nonprofit assisted living for the elderly or licensed residential care. So this is, if you were to take the just cause for eviction in Richmond and kind of put it out all on one big ugly sheet. We're not going to go through all of this, but I'm going to show you how it mirrors the state law that we just went over. So we have here the no fault reasons that you would evict somebody. So here, substantial repairs where the tenant is unable to reside. The blue one is owner move-in, and the owner intends to move in and occupy the premises. The pink is I'm going to withdraw the unit from the rental market, so the Ellis Act, and then and that's kind of all that's in here. And for each of those different things, there's a different process in Richmond that has to happen. And so this is similar to if you are familiar with practicing in Berkeley or Oakland or anywhere else that have their own little rent control ordinances. You're going to get something like this where there are different steps that have to happen for each different type of move-in or each different type of eviction that is planned to happen. So the state one is a little bit easier in that it doesn't have all of these different little pieces. But for example, if you wanted to do an owner move-in in Richmond, then you would have to serve the Richmond tenant with an owner move-in form that has a tenant assertion form on it. And this form is going to ask the tenant, do you have anybody in your home who is over 62 years old, who's disabled, or who is certified as terminally ill by a physician? Because in that case, if they've lived there for 5 years or longer, you cannot conduct an owner move-in at all. So there are little pieces that are going to come forward. Concord right now does not have something like this. They have a program which allows for non-binding arbitration to happen between the parties if they request it. Richmond is mandatory. It is not a if you request it type of thing, and it has a whole robust office that goes along with it. This other side with purple and yellow these are the for-cause things. So you can see how it's a lot shorter. Failure to pay rent is yellow. It's that one thing. You don't pay rent, you're out. You're done. None of the just cause thing, none of the whole other processes apply. And then up here, it's the breach of lease, nuisance, failure to give access. You get that written warning, right? Because you get to say whether or not you can cure that. But after that, if you don't comply, then you move forward. So much, much shorter with those types of issues. I promise no more tiny writing like that. We already talked about this. It's a complete defense to an unlawful detainer. If you fail to pay the fee, you fail to enroll, there are a lot of little steps like that which are problematic. So when we get folks who come in and they say, I think I want to do an owner move-in, but I don't exactly know how to do this without running afoul of all of these different things, we actually have all of those forms in there and can walk them through the process so that they're able to actually, get through all the different little steps. And, again, sometimes this comes back to the, okay, well, you're going to pay $8,500, if you want to do this owner move-in and do it properly, is this still something you want to do? Is there another thing you want to do to work with the tenant to come to some other agreement? Moving back to state law, we're going to talk about the portion. And we're going to go through this quickly because it's math and it's night. But the basic rule is this. There is a cap of the lower of 5% plus the change in the cost of living of that consumer price index, or 10% within a 12-month period. So the rent cannot be raised beyond that within a 12-month period if it is subject to rent control. And we're going to talk about the exceptions in a second, which again is almost everybody. Only 2 increments are allowed during that 12-month period. So if I raise the rent 3% this month, and then in 3 months decide I want to raise the rent again another 3%, I cannot then in 3 months raise the rent again 4 or 3%. Even if it's in that 10% range, or even if it's in this 5% plus cost of living, you can only do 2 increases. So whether you get up to your 10% or not is your problem. There's actually a website where you can go in and see, that's written into the law, that you can go in and see exactly what the consumer price index is and figure out whether that's going to be more beneficial for you. So right now, for example, if you're looking in the city of Richmond, it would be 5% plus their consumer price index, their cost of living change is about 3.5% right now. So you're looking at about an 8.5%. You're not going to have to memorize what that is and how it changes for every jurisdiction you're in, but you want to think about it if someone comes in with a rent increase that's above 10%, then automatically something should go off in your mind. If it's almost 10%, then you want to think about, okay, well, is this something that I want to look into to figure out what the jurisdictional limit is, or should I just be asking them, when was the last time your rent was raised? Rent control exceptions, very similar to what we saw for just cause. So your government subsidized housing, because they have their own rules for how they regulate their rent. Dormitories, your local ordinance has a lower rate. So again, City of Richmond, the rate is 3.5%. That is all that can be raised within that year without a special process happening. So even though someone's going to say, well, I didn't raise the rent 10%, they're only allowed to raise the rent according to that more protective law, in which case this would be the Richmond ordinance. New housing, 15 years or younger. Single family housing, as long as the owner is not one of those special people, the real estate investment fund, corporation, LLC with corporate member. And they have to give those magic words, that same little paragraph that I showed you when we were talking about just cause. Same thing there. Duplex when the owner occupies 1 unit. And this is applicable to all rent increases occurring on or after March 15, 2019. So remember how I said that this took effect January 1st? Well, we did that law thing where we didn't really mean it, and we were saying, look back to March 15, 2019. So if the rent was increased improperly between March 15th and January 1st, you're going to have that rollback. So the rollback is going to be to whatever it was in March 15th, plus whatever their maximum possible increase would have been. So this is to protect against folks who said, oh my gosh, this law is going to go into place January 1st, it's November, we better hike up the rent as high as we can right now. So if that's the case, and you get someone who said, I don't know what was going on, but all of a sudden my rent increased 300% in November, then you might be looking at a situation where you can do that rollback. But the landlord is not liable for overpayment in that instance. They have to move it back, and so the rent amount would adjust. But say I hiked up the rent 300%, and I got caught doing it, I don't have to reimburse the tenant whatever that difference would have been. So proper rent increase. These are just a few examples. Maybe we'll do 1 or 2, because I'm sorry. Because math. Teresa's tenant's rent is $2,400. Last week she received a letter from her landlord saying that her rent would be raised to $2,700. She lives in an apartment in San Pablo. Is the rent increase proper? So the first thing, of course, is, okay, San Pablo is not Richmond, so we're under state. She's in an apartment, so it's not a single-family home exemption. So let's just take a look at the map itself. First question is the rent increase greater than 10%? So in order to do this, you find the difference between the new rent and the old rent. So in this case, it's going to come out to $350. That is your increase in the rent. Then you're going to figure out what percentage that actually is. And I'm sorry for all of you who majored in math, who are just like, I can't believe we're doing this right now. This is something that we do on the fly. We're like, how do you calculate that again? So the question is, $350 is what percent of 2,400? So if you remember your Algebra 1, it's 350 equals what percent times 2,400? You divide both sides by 2,400, and it comes out to 0.1458, or 14.58%. Is that above the 10% cap? Yes, it is. Is that problematic? Absolutely. Tim Tennant's rent is $1,500. Last week he received a letter from his landlord saying that rent would be raised to $1,600. He lives in an apartment unit in El Sobrante. Is his rent increase proper? Again, we do this math, and we say, okay, in this case it's a $100 difference, and the $100 difference is going to come to a 6.67% increase. Is it proper? Maybe. The other question that has to be asked is, when was the last time that rent was increased? Because if that rent was increased above, say, another 6.6% 1 month before that, then this one might not be proper either. Terry Tennant's rent is $3,200. Last week they received a letter from their landlord saying that rent would be raised to $3,300. They live in an apartment unit in Richmond. Is their rent increase proper? You should say, oh no, Richmond. Richmond, you've got to look, is it greater than 3.5%, not greater than 10%? Doing the math says it's 3.125%. Again, we're looking at, has it been increased in the past 12 months? And if it hasn't been, then that would actually be proper. If it has been, assuming it's increased more than the difference between 3.5 and 3.125, then it might not be. You're going to look at these tomorrow and be like, what was she talking about last night? Okay, I think the last one. Torrance's rent is $3,200. Last week they received a letter from their landlord saying their rent would be raised to $5,500 in 60 days. They live in a single family home in El Cerrito. Is their rent increase proper?
In 2018.
So, yeah, and people are saying, yeah, why? It's this magic single-family home in El Cerrito part that's come into play. Remember, single-family home is one of our greatest carve-outs, one of our greatest exceptions. So folks can come in and say, you know, my rent's been raised a tremendous amount, and if they are part of the exception to single-family homes, and there's no local ordinance, in this case there's none in El Cerrito that's going to cover them, then yeah, it's actually proper. And I'm sorry, that's what you have to pay, and, you know, welcome to the Bay Area. This is just very quickly to tell you how I said in Richmond that you can only do the 3.5% increase. There's one other way you can increase rent, and that is to petition the rent board to allow you to increase rent for a special reason. So there's actually a process that has to be done with this. So on one side, there's the annual general adjustment, which is this 3.5%. Every September, they put out a new, here's the percentage, 3.5, 3.6, 3.4, it always hovers around there, that you can raise your rent every year. But if, say for, I put in a lot of work into this home very recently, and I completely redid the bathroom, and now I need to raise the rent because it's worth a lot more, then the landlord does have an option to go back through this second piece and file a petition form with the rent board to say, you know, I need to increase the fair rent. In order to get a fair return for what I spent, I'm going to need to increase the rent a little bit. And so there is a process through going through that as well. Again, you do not have to memorize that tonight. Just in the back of the mind go, there is some way to do that. If people come in and they ask about it, there's some way to do that, we'll figure that out for you. Again, just very quickly on Concord. So it's only Richmond and Concord right now. El Cerrito did have their own ordinance, but they retracted it. So now it's only Richmond and Concord who have just cause and rent control ordinances within Contra Costa County. Concord's is very different from Richmond's. As you can tell, Richmond's is very robust. Concord is very different. Concord says, okay, there's a 3-step procedure for how we're going to deal with this. Number 1 is conciliation with the third party. So we're going to do this mediation. We're going to get together, figure out if we can figure out a way to resolve this problem and fix this relationship. And then mediation with the third party, which is similar, step 2. and then non-binding arbitration. So we're going to go through a court-like process. Well, you all know what arbitration is. But we're going to go through a process where we're going to present our sides and have a fact finder decide who's right and who's wrong, but it's non-binding. So if we decide we don't want to go forward with whatever happens, whatever the results are, then we are not held to that. So now I want to tell you a little bit about the clinics and what we do. As you can see, it's a lot of different things. Welcome to really the basics of housing law. But these are a lot of different things that we see every day that we are in clinic, and a lot of different folks who come in on both sides saying this is absolutely bonkers. New things that just came down, and the law was crazy to begin with, and now I really don't know how anything's supposed to happen, so what am I supposed to do? And so that's why we're there. We don't charge anything for anyone. We're a complete walk-in clinic, and you can just come on in and fill out a one-page intake form that allows us to collect some data on who's come to see us for our funders. And we have attorneys there and Justice Corps who are there to assist the participants when they walk in. Clinics are held every Monday morning, 9 a.m. at Catholic Charities at the Richmond Service Center. We're also working on some in Antioch right now in cooperation with ECHO. Shout out to ECHO who's hosting us for doing that. And we're hoping to get some more going. It really depends on who's able to staff these, because I can't be at all of these. So we're really looking for folks to be able to go out and see if we can help their community members understand what's going on with some of these new laws. A little bit about the folks that we see. Unlawful detainers, they come up with a notice. I got served the notice to pay rent or quit. What do? Pay your rent. Thank you for that. We do not give legal advice, we give legal information. So we are not about, I am an attorney and I'm here to tell you what you should do. It's more about, here are the options of what you can do, here's what the law is, and here's what the process is, and I want to help you make an informed decision. Subsidized housing denials or termination. The housing authority is terminating my Section 8 voucher. I don't know what's going on. Can you help me with that? Fair housing violations, so discrimination. They told me they don't rent to families with children, or I need a reasonable accommodation letter because I need help with being able to move around the property. I need a parking space that's closer to my unit because my husband is a paraplegic and can no longer get around. Rent increase. This is the newest one that everybody's freaking out about. I got a rent increase and I'm not sure if the rent increase is proper or not. So you'd be doing those same computations in front of folks and explaining to them what applies to them and what doesn't. We also do Richmond Rent Board petitions. So the landlord needs to raise the rent because he remodeled that entire bathroom, and he says, well, I don't know what hoops I have to jump through. So we help them do all of those petitions and all of that different type of paperwork. Overall, we stock over 100 forms in the clinic. And so between forms and letters and all sorts of different things, they're all there, and we try to keep them updated so that we're really able to assist folks with many different types of situations. So who are our participants? People of color, people with disabilities, low and very low income people, single parents, limited English proficiency speakers. The only requirement that we have is that you don't make above a certain amount of money when you come in there. And so that is, but it's a pretty high amount actually of what you can make. But aside from that, and actually when people are sitting there between us and not the camera, we help whoever comes in. We want to give folks the information that they need. So I might not sit down with you if it's clear that you make more money than I do and fill out something to complain for you. But we want to make sure everybody gets the information that they need. But just generally, these are the folks who we're seeing. So about 28% of our folks are limited English proficient. We speak several languages at the clinic. We speak Spanish, Cantonese, Swedish. There was one more, Burmese. And so folks are able to help in those different languages. Of course, Spanish is one that we really, really need. So if you have other language proficiencies, then we would love you to come in and assist us so that you're able to bring in folks from that community who might have needs that we can't meet right now. 28% are disabled, and 6% are landlords. So we don't get a bunch of them. We get them sometimes, but not a bunch. I'm not sure why. We do outreach and we try to say, come on in, but usually it's because they're career landlords and they say, well, I do this all the time, what do I need you for? Like, I know what I'm doing in my business, this is my job. So, but we are available to help folks on either side. We have had situations where folks from both sides appear at the clinic at the same time, and that gets a little colorful, but we don't
And you
have
call
an attorney.
mediation.
Yeah, well, yeah, we actually do ask them. We actually do ask them. We say, you know, because they see each other, right? So they're standing, staring across the room, you know they see each other. And so we say, you know, I noticed that your landlord's sitting over there and it looks like he's coming for help too and he's not represented. You want to tell me a little bit about what's going on? Maybe we can go sit at the table outside and the three of us can talk about this. Normally they're not at that stage yet. We got to work with them a little bit first. Let them know, by the way, if you win this case, you're not going to get what you want, or your case might not be as strong as you think it is, or typical mediation stuff. Why we want to mend the relationship instead of create an adversarial one. And once in a blue moon, they do want to talk to each other, and it's great. Then other times we just say, we give them both unbiased information either way. Again, we're not giving anyone legal advice. I'm not giving you strategy against this person or you strategy against this person. We don't connect the two cases when we're talking. In fact, the person who works with this participant will not work with this participant. But we do give them the option if they see each other across the room and say, well, you're here, obviously they're here too, and no one's in a very happy place right now, and so, let us know if there's something we can do to ameliorate that, to work with that. Just a few statistics. This is a brand new clinic that we started. We started in March. We used to do these a long time, like 5 years ago. We used to do them in all the courthouses, and we had a bunch of these types of clinics where we saw thousands of folks, and then lost funding. So now we have brand new ones that are starting up, and we're really happy to have them back in the community. So far, we've done 41 of them and 455 participants, and that's only the people who are filling out the forms. Remember, each of those people represents an entire family who they're coming in, often with many children and many roommates and whoever it is. So the reach of who you're able to help in just as few short hours is really quite incredible. Let's see, what does the slide say? We assist low-income housing litigants, tenants and landlords. Okay, this is all stuff I've said before. We do forms for them, we give them information, we assist with pro-per letters. Sometimes it's just, I want to write a letter to my landlord telling him about the stuff that's wrong in my apartment, but I don't exactly know how to say it. Well, we can help you with that. We can help you write a letter. So we will sit down with a laptop and say, okay, well, tell me what's going on. And just you're a thought partner with doing those types of things and letting folks know what their rights are and communicating that. So it's not going to be a letter from you. It's not a letter from, you lawyer JD or ESQ. It's a letter from the participant, and it's empowering them to communicate and exercise their rights, whether they be on the landlord side or the tenant side. We don't tell them what they should do, like I said, and we generally do not represent them in their cases. Though some of you have asked if there are ways that you can take on representation of cases, and there absolutely is. There are a lot of folks that we assist who are not eligible for Eviction Defense Center or for Bay Area Legal Aid, which are the only kind of low-income housing attorneys in the county and senior legal services. So there are ways if you want to plug in and say, I'd just like to take a case or two here or there, or I like working with you. Maybe we can continue this relationship. There are ways to continue on working with that. So right now, we don't promise anybody that they are going to get representation when they walk in. We promise information and a smile. But if there is a way to say, if, for example, they meet Eviction Defense Center or Bay Area Legal Aid's case acceptance guidelines, then we may tell them, you are in a situation where you are getting terminated from subsidized housing and your trial is next week. This looks like, or your hearing is next week, this looks like the type of case Bay Area Legal Aid might take. Would you like me to bring it back to that office and ask them if they can take this case? So it's always a question. We never guarantee that, but if we can connect anybody with resources, we're always happy to. Clinic supervision and staffing. So what does it look like? There's always a supervising attorney who is there to clear all the pleadings and look at everything before it goes out the door. We have a lot of volunteers ranging from Justice Corps, who are trained college-age volunteers, up to seasoned attorneys. So it's really a great mix of folks who come around. We need about 2 to 5 volunteers per clinic. You're going to meet at least 2 to 3 people each time you're there. You're going to work with one-on-one. And so you're going to deal with their entire issue, whatever it is, and then you're going to be done, and then move on to the next person because there are always a bunch of people waiting. So the way that this happens is we arrive at 9, and there's usually a group of people already there waiting for us. And then we go through the list, the sign-in sheet, and we knock out as many folks as we can until we get to about 12 o'clock. So We see probably about 20, 25 folks on any given day, which can go faster or slower depending on how many of us there are. And if someone comes in saying, I've got a notice to vacate, and this is the first document I've ever received, and you have to do a lot of backtracking, the more complex, of course, it's going to take more time. We do have a volunteer sign-in sheet. You would check in with that attorney, and then you just call the next person you're assigned to and cross off the name and move down the sheet. So it's very, very organic, easy to follow. Here's our sign-in sheet. The folks write their name. They write if they need Spanish assistance, and then where they are, if they've received a summons and complaint or a notice to vacate, just so we know that those cases are going to take a little bit more time. So say you were ready to take number 1, then you would just cross out that 1 so that we know whoever's coming in next can take number 2. Or if you can't take them because say they are a Spanish speaker and you are not, then you move on to number 2. Very simple. So the procedure for helping folks is you introduce yourself, you review the intake sheet with them, make sure it's all filled out, explain the scope of services, which is pretty much, we are here to help you help yourself. We are here to give you information, not advice, and we are not your attorneys. And so as long as we don't want folks coming back the next day to Catholic Charities saying, where's my attorney? And feeling like they're going to have someone, well, this person was supposed to represent me in court tomorrow. We want to make sure that there are clear expectations, folks know what their next steps are, and what our relationship is with them. This is the intake form. Like I said, it's 1 page. It's very short because it's not like being at a doctor's office. And a lot of it is information which can help us determine how to help the participant, but a lot of it is also just boring stuff like what is your name and what city do you live in. The bottom part is the part that's important. So the bottom part says, this talks about, this is the legal disclaimer part. This is the part that talks about what our relationship is with the participant. So while they're waiting for an attorney to come sit down with them, we want them to read this material and to sign off that they understand this. So the clinic is here to help me help myself. The clinic will not be giving me legal advice. The clinic is available to help both parties. And conversations between me and the clinic staff are not confidential. We tell them that because we're pretty much in a room like this. So you might have someone sitting here and someone sitting there. We're not actively going to be sharing your information with anybody else, but it's a big room, and so we're not having a confidential conversation. So what you would do procedurally, you'd be interviewing them to gather the facts, and then if you're not sure what to do next, that's when you go to the supervising attorney and say, okay, I've got this notice to vacate, or I've got this situation where this person is needing a reasonable accommodation because of X, Y, or Z, and I'm not sure where to go. What can I go through with this? So you're not expected to memorize or have all of the law down or everything already. The main thing that you need to be able to do is come in and listen and issue spot and not make people feel completely uncomfortable. So if you're able to do that, then you're already on the right foot and you're able to really hit the ground running with our folks here. You provide the assistance, the legal information, or assist with the forms. The supervising attorney will always review those forms at the end. So if you feel like you don't quite remember how to do a proof of service, it's okay. There's always somebody there who's able to help you and always able to review those things just in case. And then at the end of it, you will collect the completed forms. The intake form, which is the one we just go to, goes into a pile. And then there's also a little survey that we give to folks to ask them how they liked our services. Then you would fill out the back of the intake form, which is the part that says, what did we do with folks? And I'll show that to you in a second. That's what this looks like. And it's very simple. It's I check this person's income, so you can see for one person, they can't make over $5,750 per month if they live by themselves. And then did we give them information? Did we help them with preparing a document? Or did we refer them to another agency? So we collect that information, and then that's pretty much it. You're done. This is the takeaway slip. This is what we give folks to let them know that we won't be here the next day, but to give them somewhere to turn to if they have further questions. Because I don't want anyone giving out cell phone numbers or them hunting you down. So if they have questions after clinic and they cannot wait till the next Monday, we give them the legal advice line phone number where they can call and speak to an attorney right away. We also give them on the back of this sheet a next steps page. So oftentimes when we're meeting with folks and we're giving them all of this information and their brains feel much like yours are feeling right now, they're not going to remember what they have to do next, including please bring these forms to court and file them. So we write down what the next steps are for them, so they're able to take that with them and remember it later. This is a little satisfaction survey based off of Baymax from Big Hero 6. How are you feeling today? And it's just one of the ways that we gauge how folks are feeling, if they like our services or not. Our forms are all available in English and Spanish right now. We're hoping to expand to other languages. And we do provide any type of interpretation as needed. In-house referrals, like I was saying before, sometimes there are cases that can be taken in either by Eviction Defense Center, who's our partner, or Bay Area Legal Aid, in which case we want to know about them. If you think it's something that involves subsidized housing, then we like to know, or fair housing, then we like to know ways that we can help those people beyond the clinic, and that just might be an issue spotting issue. Then outside referrals, we love to get to know as many of our community members who can help as we can. For example, we have a lot of folks who come in and they just say they don't have a housing issue. Their issue is they don't have the money to pay rent next month, and they didn't know where to go. And so it doesn't help if we tell them, okay, well, here's the process. You're going to get a 3-day notice. So what we like to do is know as much as we can about different things that can help them within the housing world. So for example, Shelter Inc. and Seasons of Sharing are both programs which allow those types of financial assistance, so we can give them information on that. We can direct them to SparkPoint if they're interested in doing some like consumer debt cleanup types of things. And like I said, the Eviction Defense Center is a great one who also helps. They're located in Oakland, but they're also helping with some of these enrichment cases that are going on right now. This is our clinic document order form. This is not meant for you to read. This is just to show you that we have a lot of forms that hang out at the clinic and that they're certain ways so you can find them very easily. And that this changes all the time. Every time we get a new law that comes down, there's a new form letter that comes out. There's a new motion, there's a new something. Things come in and out of this. It's a very organic list. And so if you are in your practice and you're like, you know, I think we really need a letter to show folks how to do this or that, and you either need one or you want to give me one, then let me know, because we like to provide those. All of the stuff we have, none of it, we don't hold on to it as proprietary. We want to just give it out so folks have that information. This also tells me when we're running out of staples. So lastly, clinic logistics. So where is it? It's at Catholic Charities Richmond Service Center. That's 217 Harbor Way in Richmond. We also have a second one, like I said, in Antioch that's just starting up. If you're more interested in working in East County, we'd love to see you at one or both. We are there Mondays 9 to 12. To tell you the truth, we're probably there more till 1 because we're always working a little bit longer than we're supposed to be. But if you have an hour, you have 2 hours, you have one Monday, you don't have to continuously be there all the time. You can say, I'm going to dedicate one Monday a month that I'm going to come in, and I'll be there the first Monday of every month. That would be fantastic. We'd love to have you. This is my information, so please feel free to email me if you have any other questions or if you want to volunteer. I think we do have volunteer forms somewhere here if you would like to sign up. But we'd really love to see you coming out. Even if you think you want to do it, then that would be great. We have MCLE forms and other sign-up forms here as well. Please put your information on that so I can send you more information on how to get involved. And if you have any other questions, then we'd be happy to continue talking about this. And the Congress of Neutrals wants to say something.
Yes. Other than saying that Congress of Neutrals is here, we train mediators if somebody has done 40-hour training with another agency. We have a mentorship program where you can sign up. We'll assign a mediator to you, and you can go to court with us, and we'll train you in mediation. Hopefully in unlawful detainers, because that's where we need help. Other than that, there was one other thing. You mentioned ECHO, and Pedroza is here. They have an opening for an attorney, and you can get more information from DDA.
Yes, that's right. ECHO just got funding for a new housing attorney.
Yes.
So we desperately need attorneys in East County working on housing. If you know of anybody, Delia right here is the one to see. Or if you want to come and hang out at the clinic for a little while and get to know housing and then apply for that, then that would be fantastic too. But anyway, please keep it in your mind. Thank you so much for being here. Really appreciate the time you've given and the interest, and hope to see you at one of our clinics.
Yeah. So I'd like to say thank you to Tamina first So thank you very much. I'd also like to ask Commissioner Lee to just come up briefly and say hi to everybody. Commissioners Lee and also Commissioner Cruz, who couldn't be here tonight, were kind of the instigators of us trying to get things going with the housing clinic. And as conversations started, I think someone was either in your courtroom?
Yeah, I had someone from Bay
From
Legal
Bay
in my
Legal.
courtroom.
And then they contacted me, and so basically that's how all of this happened.
So hello everyone, thank you so much to Bay Legal for being here, and for all of you, this is a really impressive turnout, and we're so thrilled. Myself and Commissioner Cruz, who really wanted to be here, and I can attest, I spoke to her on the phone, she sounded horrible. She's got little ones at home, so they bring everything, and then she catches it all. But this is a project that's really near and dear to us, and I just joined Contra Costa Bench in 2019, so I haven't even been on a year yet, and Commissioner Richards was my mentor and teacher. We're desperate in need of people to volunteer, so the very fact that you're out here, hopefully, if you can find the time, one of the most difficult things, and particularly in Richmond, is that equity. And we have so many disenfranchised tenants coming in who are in desperate need of representation because the court is limited in what we can do. Like if there's a defect, boom, good. A demur, great. But beyond that, there's no advocacy. And so it is really difficult. And also for the folks to understand what habitability is and what it isn't and what they're entitled to and what they're not. There's also landlords too. I don't want to make it sound like it's all just leaning towards the tenant. There are landlords as well who have the tenants from hell, who are struggling financially. This is their only source of income and they need your assistance. But thank you so much for being here. I am so happy to be part of this project. This turnout was, when I walked up, because I was late and I'm sorry about that, I was shocked at how many people were here. It's awesome. And very legal aid is near and dear to my heart. My career started at Legal Aid in Marin, so I'm a Legal Aid fan from way back. So thank you so much, and thank all of you. And hopefully I'll see some of you in my courtroom. And I won't trip. I can't promise I won't trip. I see a couple of you in there all the time, just in a different uniform. Thank you all so much. Thank you.
Okay, so Tamina had mentioned, we'll make sure that we forward the PowerPoint to you so you can actually see some of this information a little bit bigger. But if you want, I know everybody has signed in, but if you are interested in Tamina connecting with you about volunteering for the clinic, just put a little, yes next to your name, and I will send your email and everything over to her, and then she can connect with you directly. So again, thank you all for being here, and have a wonderful evening. Thank you so much. Oh, you.